Recently, a law school graduate who belongs to a subsect of the Sikh religion wanted to be called to the bar in Alberta, but balked at making a pledge to the sovereign, that being the Queen at the time, His Majesty the King, King Charles at present. Recently, the Alberta Court of King's bench struck that down, and I thought it would be an interesting case to look at and discuss, and also why I think the Alberta Court of King's bench got this one right. And again, remember, if we get to 10,000 subscribers on YouTube before the end of the year, I will regrow my handlebar mustache. We've been stalled out at 7.78 thousand subscribers for about 2 months now, but there's still time for us to get there. Hello, my name is Nicholas Wansbutter. I'm a lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. So one of the things that all lawyers have to do in order to become a lawyer and be allowed to practice is they have to take certain oaths, and one of those oaths is to the sovereign of the nation, the head of state of our country, and by making that oath, pledging to uphold the laws of this country. It always seemed to be a very reasonable and rational requirement to me that the people who are in the courts arguing what laws are, arguing for interpretations of law, and ostensibly charged with upholding the law would at least make the gesture of an oath or a promise to uphold the constitutions of our country and of loyalty to the country itself, which in a constitutional monarchy such as Canada is embodied in the crown. Now, obviously not everyone agrees with me on that, and I think it's not surprising that an individual who originates from another country disagreed with that, because he grew up in different traditions. There would be different requirements for lawyers in that country, and didn't want to follow our ways, but wanted to practice law in Canada. That's the case of Mr. Wearing that we'll look at today. So first we'll look at the news clip on the case. We'll look at the case itself, as is the practice here in Don't Talk TV. We look at the actual case, not just mainstream media or alternate media's reporting of it. And I'll make some brief commentary on my thoughts on the case, which, spoiler alert, as I said at the very beginning, I think the Court of King's Bench of Alberta got this one right. So just starting very briefly with this CBC News story titled, "Judge Dismisses Prospective Lawyer's Challenge Over Mandatory Oath to Monarchy," one of 3 sworn to be called to bar. So I've compared this article to the actual case. I think it gives a nice synopsis, so it helps speed up things a little bit by looking at this first. So it says here that a challenge to the Law Society's Oath of Allegiance launched by an Edmonton articling student last year has been dismissed. Prabjot Singh Wearing is a devout Amritari Sikh. He made an absolute oath and submitted himself to Akal Purakh, the divine being in the Sikh faith, and is prohibited from making a similar allegiance to another entity or sovereign. In Alberta, provincial legislation requires lawyers to swear an oath to be faithful and bear true allegiance to the reigning monarch, their heirs and successors. Now, it seems to me that by being prohibited from making any allegiance to another entity or sovereign, this gentleman is essentially prohibited from being loyal to anyone or anything other than this divine being of his Sikh faith, which is his right to do, but I don't think he should be expecting countries or people that he is not able to swear any allegiance to entrust him with certain public offices. It would seem to me that that's a basic minimum requirement of holding a public office, but I'll get into that a bit later. Let's look at the case itself and how the Court of King's Bench came to reject his application. So we have the Court of King's Bench decision here. Prabjot Singh Wearing and Law Society of Alberta and His Majesty the King in right of Alberta. So as the news article alluded to, this case involves the plaintiff, Mr. Wearing, claiming that portions of the oath mandated by the Legal Professions Act violates his rights to freedom of religion and freedom of equality under the Canadian Charter of Rights and Freedoms, and are not justified under Section 1. So Section 1 being the reasonable limits, we've discussed that before. Again, if there were no reasonable limits, then maybe this would be a no-brainer that, yeah, anyone can come to Canada, hold any office, and doesn't matter, if long as you have some religious belief, you don't have to abide by the rules that everyone else does. So a bit of more background here. He attained a law degree from Dalhousie. In June 9th of 2022, he filed a statement of claim. Now, this is interesting that he raised no concerns with respect to other oaths. It was just the oath to, as it says here, the oath of allegiance, requiring that the person affirm, "I will be faithful and bear true allegiance to Her Majesty the Queen Elizabeth II, her heirs and successors according to law." Now, the decision does give an interesting review of the history of development of these oaths. Link to the decision is in the show description, as always, so you can read those details if you like. I'm skipping ahead to paragraph 103 and following to get to the meat of the decision here. So it says that at paragraph 104, in considering the meaning of the Oath of Allegiance, it must first be recognized that Canada is a constitutional democracy. The monarch is both the head of state and a symbol of sovereignty. And as you'll see, this is key to the decision. So they review some other cases in Rehib, or Hybe, not exactly sure how that's pronounced. The federal court considered the appellant's conscience-based objection to swearing the Citizenship Act oath and concluded that the oath can be regarded not as a promise to a particular person, but as a promise to the theoretical political apex of our Canadian parliamentary system of constitutional monarchy. In Roche, FCA, the majority of the Federal Court of Appeal likewise opined that the oath properly understood was an expression of agreement with, quote, the fundamental structure of our country as it is, unquote. The Court of Appeal of Ontario in McKeeter concluded that notwithstanding the Queen as a person, quote, in swearing allegiance to the Queen of Canada, the would-be citizen is swearing allegiance to a symbol of our form of government and the unwritten constitutional principle of democracy, unquote. Now, I think on this basis, the court could have, and in my view should have, held that this is a bare minimum to be a lawyer in Canada. You have to at least be accepting of our parliamentary system and our democracy, our constitutional monarchy. Paragraph 125, the court kind of confirmed what I've said here, that the integral role that a member of the Law Society plays in upholding the rule of law and ensuring the administration of justice is not impugned is further reflected in the Law Society's Code of Conduct. And it states that a lawyer must encourage public respect for and try to improve the administration of justice. The Oath of Allegiance is the symbolic commitment made by prospective lawyers to this important role within our constitutional democracy. So again, this should be a bare minimum, it would seem. How can you encourage public respect and try to improve the administration of justice if you refuse an oath of allegiance to the principles upon which it is founded? The court went on, following those cases that I quoted, to find that the oath to the Queen is not to an oath to a person, but to the rule of law in accordance with our constitutional form of government. And following on that, paragraph 145, the court noted Mr. Wearing's willingness to swear other oaths which reference abstract concepts like the sovereign's interest, the public interest, and the rule of law. So it's on the basis of that at paragraph 178, the court held that, well, he can swear these other oaths. The Queen, it's not an oath to a person, therefore him claiming that it's an oath to a person, and that's why he can't make the oath, he's actually misunderstanding the oath. Therefore, his religious freedom is not incurred, because he was stating that it was that oath to a person that he couldn't do. And then in assessing the Section 15, the equality argument under Section 195, the court, of course, had to make note of, I guess they're not allowed to disagree with that Sikh people are racialized, that they're discriminated against, that they're downtrodden because of their skin color and because of their religion. But the court held that broad evidence of historic disadvantage is insufficient to satisfy the causation burden in the first step of assessing whether a person has been denied their equality. So, since Mr. Wearing has not demonstrated that the Oath of Allegiance requirement in the LPA creates or contributes to a disproportionate impact on his version of Sikh based on the religion or race, there is no need for me to proceed to the second step in the analysis. So they rejected that one as well. So I said I'd give some brief thoughts on why I think the court got this right. What I would say is I agree with the outcome, not necessarily the reasoning. Although I don't have any issue with the reasoning, I think it's correct, but it seems to me that it would be a valid restriction on religious liberty under Section 1, that in order to hold an office like lawyer or a government position or police, you have to you have to be able to have that minimal adherence or pledge of allegiance to our rule of law, to our system. And the fact that it's considered normal, I mean, 30 some professors argued in favor of this individual not having to swear the oath. This is part of why we have a breakdown of the rule of law. And this is why this sovereign citizen nonsense is so popular among individuals, because there's no respect hardly anywhere for the rule of law or for our institutions or for our constitutional monarchy. So people can go off in all kinds of different directions. In my view, we need to get back to this principle that there are certain minimal things that are required to be a member of Canadian society, to be a Canadian citizen, to participate in our system. And if you're not willing to adhere to that, then, well, I'm sorry, but then you're not holding those positions. And this has nothing to do with me being white or me being a heritage Canadian and being racist against non-whites. The absolute same holds true. If I went to India, I would absolutely expect to adhere to whatever cultural or legal requirements that they have there. I would not impose upon them my values. I don't think it's right for anyone to impose their values on another person's country. If you are going to another country, you should integrate and adhere to their society. So in India, I'm sure, I don't know what's required to become a lawyer there, but if there were an oath that was required that I felt I couldn't take based on my religious beliefs, I would say absolutely I should not be allowed to be a lawyer there, and rightly so. They have the right to have their own culture, to have their own system, and they should cherish it. They should uphold it. I am 100% in favor of that, be it India, be it any other country. And when I say be it other country, I include Canada as well. So I'm fully in favor of the end result, at least, of this decision. But of course, this video is not legal advice. If you need legal advice, as usual, call another lawyer or myself. Contact information below. If you have any ideas for show topics you'd like to see me cover, please send that to the email address listed below. And if you found this video at all interesting, helpful, or informative, please consider liking, sharing, subscribing, especially subscribing on YouTube. Try to get us to 10,000 subscribers before the end of 2023, and so you can see a return of my handlebar mustache.